Thank you for coming. My name is Carmel Shachar. I'm Executive Director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics. We're delighted that you could make it today. This is the launch of our newest volume, Law, Religion, and Health in the United States. So if you were looking for another event, too late. I hope you enjoyed this one. This book came out of our 2015 annual conference, which really looked at the intersection of religion and health, especially these days as health becomes more secularized. There's an increasing conflict at times between religion and health. Law itself can either mediate these conflicts or perhaps aggravate them. The conference itself was very successful, and we were delighted to have this volume come out of the conference, further exploring these important themes between law, religion, and health. To launch this book, we have a host of people who have some very interesting things to say about the intersection of religion and health. To introduce them, we first have Glenn Cohen, who is Professor of Law and Faculty Director at the Petrie-Flom Center. He was one of the co-editors of the volume, as well as contributed a chapter on reproductive technology. We have Diane Moore, who is the Director of the Religious Literacy Project, Senior Lecturer on Religion, Conflict, and Peace, and Senior Fellow at the Center for the Study of World Religions at the Harvard Divinity School. She was a contributor to the volume exploring the evolution of the Religious Freedom Restoration Act. We have with us, not in person, but in spirit and mind, Elizabeth Sepper, who is Professor of Law at Washington University School of Law. She was co-editor of this volume, as well as contributed a chapter on contracting religion. And moderating this panel, we are lucky to have Intisar Rab, Professor of Law and History, as well as the Director of the Islamic Legal Studies program here at Harvard Law School, the Susan S. and Kenneth L. Wallach Professor, and Harvard University Radcliffe Institute for Advanced Study. And so with that, I turn it over to our esteemed panelists. Intisar, if you would like to kick us off with a bit of introduction about the volume.
Great, thank you so much. And thank you to Glenn and the Center for inviting me here today, and for all of you for coming. I've been to a number of these, and this is a really great turnout, showing the salience of the issues that are covered in the book, Law, Religion, and Health in the United States. So I'll just say a little bit about, a couple of words about what the book is about and why I think it is important, and some of the larger implications that I found when reading it. And so I was really excited to have the opportunity to read this book and almost with an advanced copy of it. And then I'll go to turn it over to Glenn, who will say some of the background motivations for the book. And then each of the panelists will say a couple of words, and then we'll open it up fairly quickly so that all of you can engage the panelists, who are also authors in the book, about it. So Martha Minow, our former dean here, wrote the foreword to the book, and I think she really began to really place the book in larger context by laying out some of the thorny problems that it addresses. The problems arise given the political and social moments that we find ourselves in, and the political and social movements in response, and those specifically that have focused on religiously inflected issues for the past several decades, from abortion to the nature of families to the rights of LGBTQI individuals, and I would add now matters of life and death when it comes to the death penalty or euthanasia, and I'll say a little bit more about that at the end for a reason that the book was of particular interest to me. So the public and political debates and changing constitutional law doctrine in recent years, they reflect the debates on the ground, as well as changes in medical technologies, expansion of the government's role in healthcare and the ACA, which still lives after yesterday, and shifts in medical ethics from reliance on medical expertise to individual choice. So Martha highlights a few problems and questions in this way. She said, Some of the problems that we continue to grapple with include: what is the test for determining when an assertion of religious free exercise deserves constitutional concern? Is it the opinion of religious objectors? Is it sincerity? Is it recognized religious doctrine? Is it unique adverse effects to one religion over another? What kind of countervailing concerns justify tying claims to religious exemptions? Preserving life, public health, the standard of medical practice norms. And finally, when should courts have the final word, and when should legislatures? What room is and should there be for compromise and settlement of religious claims? So these are some of the big picture questions that the book tackles with some of the leading scholars, practitioners, and professionals that are working at the intersection of law, religion, and health in the United States. And then the editors give the most succinct and useful breakdown of the constitutional and statutory doctrines on the intersection of law and religion in the US in general. And so I'd really commend it to you. It's about, I think, 10 pages long, but it really sums up our doctrine and history since 1963. And also the ways in which those doctrines intersect with questions of health. And they end with two powerful paragraphs that I want to read here because I think it also really gave a great representation of what the book is about. So they write that the chapters in this book describe, analyze, and evaluate the myriad new and enduring challenges at the intersection of law, health, and religion. They intervene in areas of legal change and medical advances. The fundamental issues are the same as they have always been, balancing religious liberty against equality, health needs against spiritual commitments, oversight against autonomy, collective against individual. But tensions today are undoubtedly high. And collectively, these chapters offer insights on where religion and health law intermingle, what the legal doctrine gets right, what it gets wrong, how public policy might respond, and what future unanticipated conflicts may emerge. With healthcare reform up for grabs again, and religious freedom law in flux, the chapters here chart a course toward where we should be going and provide guideposts for evaluating current and future proposals for reform. Whatever happens in the near future, it's very clear that the intersection of religion and healthcare will view the law for years to come. So they present in the book the current state of the field all in one place by these leading scholars and practitioners. And as the book shows, these questions have yet to be resolved. But they show the ongoing salience of these debates in the context of other health debates, and they become instructive for other contexts of life and death as well. And I want to give one quick example from a context where questions of health, law, and religion intersected when it came to Islamic law and capital punishment in a recent death penalty case. So in 2015, the Supreme Court effectively told Alabama death row inmate Demetrius Frazier, who was a Muslim, that he must choose how he is to die. Really, the case was about another defendant, and the case was called Glossop v. Gross. And that case required death row inmates objecting to lethal injection protocols to propose a constitutionally acceptable way of putting themselves to death. Demetrius Frazier, who was subject to the Glossop standard, argued that to do so would go against his religious faith, Islam, because suicide was prohibited under Islamic law. So Frazier's case represents a clash between First Amendment concerns and Eighth Amendment concerns, indeed the jurisprudence of the US Constitution and related statutes. And it can only be resolved through considering questions at the intersection of law and religion and the definition of conscience and complicity and life and death. And all of these are the very questions that are grappled with in this context, in the context of this book on law, religion, and health. in the United States. So with that, I will turn it over to Glenn to tell us a little bit about the motivations behind the book.
Thank you very much. So first of all, for those of you standing, there are 4 seats over here, so please feel free to come forward. We hate people have to stand or sit if they don't want to. I'm going to be brief. I'll say one word about my own chapter, and then I'll say a little bit about the book in general. But let me start by thanking some people who were very helpful on the conference that gave birth to this book. Chrissy Hutchinson-Jones, our administrative director, Justin Leahy, our part of our staff who's sitting right over here, and then 4 of my RAs. I think they've all graduated except one, Ariel, but I don't see her in the room. So if you're here, Ariel, you can raise your hand, but they're always extremely helpful in getting the book together, and I'm grateful. My chapter is on reproductive technology and religion. Easy peasy stuff, right? No controversies there. And it's to examine the way in many other countries the role of religion in setting reproductive technology policy. In Spain, Italy, and France is pretty obvious. In the United States, it's a little less obvious because our reproductive technology regulation is so decentralized. So my chapter, and happy to talk about it in the Q&A, looks at adoption of embryos, embryo adoption programs, and the way in which the Snowflakes program, which is the one President Bush highlights, requires you to be a good Christian to agree not to have an abortion, among other things. Kind of interesting. A discussion of personhood amendments that are seeking to recognize the legal personhood of fetuses and embryos before birth, very early on in kind of the political landscape. Discrimination by providers against LGBT individuals in providing reproductive services, and then also the way in which religious groups are starting to intervene in cases about embryo disposition, where couples disagree about how to dispose of embryos. One wants to use it for reproduction, the other doesn't after a divorce. So happy to talk about all of that, but I want to talk about the book more generally. So we had this conference. The motivation was Hobby Lobby, right? We thought, oh, okay, Hobby Lobby happened. We should definitely have a conference on this. But when we started looking, we realized that the issues were much bigger than Hobby Lobby. Now, those of you who aren't familiar, Hobby Lobby is a question about the contraceptive mandate, which is part of the Affordable Care Act, requiring insurers and employer-sponsored insurance to cover contraception, contraceptive services, and was challenged under RFRA, the Religious Freedom Restoration Act, as prohibited. RFRA, just a little bit of the history, was this case Smith by the Supreme Court, establishing that the Constitution doesn't apply to generally applicable laws that happen to sideswipe religion, and then RFRA restored the pre-Smith jurisprudence to a much higher element. So while the book was in gestation, the Supreme Court decided in another case, Zubik from the Little Sisters of the Poor, and this was a little bit frustrating as you're writing this book and finishing this book, and go back to everybody and say, hey, hold off, don't do your chapter yet, right? Edit your chapter about on this. But I think what was most interesting about the book is the first part of the book really is about Hobby Lobby and Zubik and this dispute. We've got actually the litigators on both sides of the case arguing their cases in print. It was fun to see them in person over lunch, right? I think that, I don't know if they ate very much, but it was really good entertainment, and they're good sports too. We have Doug Laycock, who's probably the most revered religion and law scholar, arguing that Hobby Lobby was rightly decided, but Zubik wrongly decided, which is kind of an interesting take. What I love about the book is we tried to go beyond this single dispute to think about the larger field. The book, I think too often, religion and law, and particularly religion and health law, is poised as Christians versus the rest of the world, right? That's kind of the way it's presented. But in the book, we try to go hard to see the ways in which other religious views intersect with healthcare, whether it's actually Santeria and kind of the ways in which liquid mercury as part of some of the rituals in Santeria involved, whether it's burial rituals in West Africa, for example, and the way in which that might get in the way of some of the Zika containment effects and the laws on public health, whether it's Islam, whether it's Judaism, whether it's actually Native American religions, and kind of the way in which they intersect with environmental law. And what I love about the book is there's just a ton of things that I would never have thought about, but the people who wrote the book and who submitted their chapters, the other authors, kind of raised my attention to me. Whether it's about what it's like to be HIV/AIDS positive in a black church and what the experience of black men who have that is in terms of the social world they face. Whether it's about the Amish and kind of some of the ways in which their activities do or do not gel with environmental law and public health law. Whether it's about minors and how in which their refusal for interventions on the basis of religious beliefs ought to be treated. Jonathan Will did a talk about that. whether it's Orthodox Jews and other religious minorities, and whether their own views about when death occurs should trump the law on determination of death. That is, whether the determination of death statute in the state should allow you to opt for your own religion's definition of when you're dead to trigger legal consequences of death. These are just some examples of the multiple ways we look at this. We look at everything from psychotherapy to abortion to the disposal of bodies to the role of feathers and eagle feathers in law for Native American communities. So it was a great pleasure to get to edit this book. It's a very wide ambit. And of course, the Supreme Court litigants keep us busy. I'm excited to see how Masterpiece Cake, not healthcare thankfully, wedding cakes, which are very important too, to be clear, how the Supreme Court's continued discussion of these issues impacts the field of healthcare and the field of what we do.
Great. Diane? Well, first of all, thank you for inviting me to this and for inviting my co-author, Eric Stephen, who I don't think is here. He really deserves a tremendous amount of credit, primary credit for this chapter. So I'm sorry he's not here to take that credit. But I wanted to say a word about the larger context in which this entire debate takes place. Our chapter is on the morphing of the Religious Freedom Restoration Act from an incredibly bipartisan, wholly supported legislative act in 1993 to then it was declared unconstitutional at the federal level in 97, and then of course states picked it up. And the current iteration of the Religious Freedom Restoration Act is being used in a very different way than the original intent of the first act in Congress. And so we talk about the confluence of factors that came about that created that shift. And I think the two things I want to just highlight are that one of the things I'm excited about with this volume is it doesn't reproduce lots of what often happens when we're talking about religion in public life, which is a more reified version of religion. It really recognizes the incredible complex nature of religion, the fact that religions are internally diverse, they evolve and change in time, and that they're embedded in so many dimensions of our experience, as opposed to more common ways of understanding religion, which is to treat it as this isolated entity. And I think the current climate represents that really powerfully. And so it gives us a chance, I think, to really understand the power of religion and to give citizens language to be able to interrogate the roles that religions are playing in all sectors of society. And I think this intersection of religion, health, and law is a really, really rich one. And this volume is exceptionally fine, I think. And I'm very proud to be part of it and just want to say thank you to the extraordinary work of the editors. I don't know how they turned this around in a year. And you know, these can often feel slipshod. This is not that at all. So a couple other things I want to say is just to say, I want to really encourage you to also take a look at Martha Minnow's preface, because she shapes, I think she models, in a way, a really wonderful understanding of these complexities, where she roots herself, she owns her I voice in her own take on these complex questions, but doesn't try to then normalize that voice or universalize that voice, and really highlights the fact that our institutions actually are not well equipped to deal with these complexities. She points out the problem with the nature of our legal system, that it is adversarial, almost by definition, and how that complicates the capacity to really deal with the deeply contextual nature of so many of these decisions around religion, and the fact that we need to think in some new ways about that. And the other thing I want to raise is to just say, again, the power of how religion is being, I don't want to use the language manipulate. I'm going to say just the truth of religion is that it's always involved in political, economic, and social causes. And the morphing of the RFRA from its original inception to the current iteration is a case study in something that is widespread. And giving language to helping us ask different kinds of questions about the role of religion in our public discourse about these issues is one of the things that I feel like this volume will really help contribute to. Because we tend, again, to have these debates and then they become these binary fights about the nature and the appropriate role of religion. And we can't have that binary function in any way that will in any way promote a civic conversation, let alone the skills and tools of what it means to function as democratic citizens in a diverse, multicultural, multi-religious society. And so our institutions, our legal, our medical institutions, need to really wrestle with the complexities of the ways religions play out in this contemporary moment, and to understand how this contemporary moment is not inevitable and how it absolutely is the consequence of very intentional acts on the part of some, and also then the challenges of those acts on the parts of others. So this dynamism of religion is something that I feel excited about the volume, and also feel excited about what it can contribute. And then the only other thing I want to say related to that notion of embeddedness, the nature of how religion is embedded. You know, Glenn, you said that this volume, or often when we think about religion and law and health, we think of, you know, Christianity and law, or Christianity. And I'm going to say, actually, that's true. Because the systems themselves, the institutions themselves, are deeply rooted and influenced by Protestant Christianity in the United States. And so actually, it is about Christianity, because we have a fundamental kind of template, if you will, that then all other religions need to fit into, because the template is rooted in an unconscious, or unarticulated, I should say, fundamental set of assumptions about the influence of Protestant Christianity. And that's a very large conversation to have, but I just want to say that it actually is about Christianity, even though all these other traditions and religions, and I think that consciousness is also really important, because to recognize the hegemony of Protestant Christianity in all of our public institutions is a really important part of religious literacy, not to then challenge its legitimacy, or, you know, not to then participate in this challenge of whether that then delegitimizes the institution, which unfortunately would be the kind of discourse we're having now, but rather to be aware of that influence and the nuance and subtlety of what that represents. So again, I'm really happy to be here. I'm so happy to have you all here, and look forward to our conversation. So thank you.
Yeah, thank you. Yeah, it is striking that you notice that the language for exemptions is exemptions for churches.
Completely.
And cognate institutions. Yeah. But, well, I'm sure I have more questions about that. Liz?
Thanks for having me. Sorry that I can't be there in person with all of you. I think I'm going to pick up where Diane left off, talking about more of the shifting legal framework than the shifting political culture or debate. So I just want to highlight two things. So essentially, we have two different protections for religion. We have the Religious Freedom Restoration Act, and we have state corollaries in many states, about half of states, and then the First Amendment in the Constitution. Also, there are also state constitutional protections, but I'll leave them aside for now. And then we have, of course, a number of statutory exemptions that are quite specific. For instance, you know, you enact a law providing for employers to pay Social Security, and then you exempt Amish employers whose employees also don't want them to pay Social Security. We have a whole regime of very specific statutory exemptions. And in recent years, we've seen shifts in these legal structures. So with regard to RFRA, Hobby Lobby was really a sort of break point where the Supreme Court described the Religious Freedom Restoration Act that responded to a Supreme Court opinion as not restoring the pre-Smith constitutional jurisprudence, but rather making a break with that jurisprudence and imposing a much more rigorous standard for review of government regulation. Now, in the form of Masterpiece Cake, we're seeing the potential for the First Amendment to shift in form, and the arguments that the cake shop is making with regard to the free exercise clause either require overturning Smith in some way, or really expanding some of the case law in ways that could lead to exemptions, constitutional exemptions from lots of different laws. So the Religious Freedom Restoration Act only applies to federal law now, but if the court were to find in favor of the cake shop on free exercise grounds, that would affect all sorts of state legislation and regulation. So we're really seeing legal principles and doctrines shift. And one thing to keep in mind, of course, is we're seeing these sorts of developments being driven by evangelical Christianity primarily, conservative Catholicism joined with it frequently. And that looks quite different from our previous Supreme Court cases where the litigants tended to be from these minority religions, Jehovah's Witnesses, the Amish. And so that seems to be a significant change, driven in part, as Diane mentioned, by our adversarial system. An adversarial system where we now see legal social movements establishing very well-funded, very smart litigation shops like the Alliance Defending Freedom that can seek out and build out these doctrinal shifts. So I just wanted to lay the lay of the land with regard to the law and then briefly talk about my chapter. So my chapter is about contracting religion. And it looks in the way that healthcare institutions create religious identity through contract. So I use the case study of Catholic hospitals because they're really the main religious actor in healthcare institutions. They're dominant, both compared to other nonprofit health systems and with regard to other religions. And when you think about contract creating religious identity, it seems problematic, right? If I enter into a contract with you and say, okay, you're now Catholic, or now you do what a good Catholic would do, that might strike you as problematic. But on the other hand, if you think about it this way, a Catholic hospital that has all sorts of restrictions on care requires its staff to comply with those restrictions on care and does so through contract. Where this gets especially problematic is that throughout the healthcare system, as we go through times of consolidation, we see Catholic healthcare entities and other religious entities as well, contracting to create joint ventures, sort of looser affiliations with non-religious hospitals or non-religious nursing homes or so on, and saying as a condition of this joint venture, as a condition of our affiliation or cooperation in some regard, you too need to follow Catholic doctrine in regard to reproductive health care and end-of-life health care. And we're also seeing a phenomenon where not only are Catholic hospitals purchasing other hospitals, and then sometimes they remain secular but comply with Catholic doctrine, but we're also seeing Catholic healthcare systems sell off hospitals. And frequently those hospitals continue to comply with Catholic doctrine. So they're no longer Catholic, they don't have Catholic ownership, they don't have Catholic administrators, but they still comply with the restrictions, often in a way that is not transparent. So that's sort of a central concern for me, not one that currently is in the process of litigation under RFRA or under the First Amendment, but where we see a space in specific statutory exemptions or absence of regulation, allowing the proliferation of one faith throughout the healthcare system.
Great. So thank you for that, Liz, and to all the panelists. And at this point, I want to open it up to all of you. Do you have questions? And if you have a question for a specific panelist, please say their name first so that it's directed to them. And there's a microphone going around. While you're thinking about your questions, I will just ask one to all of the, or two questions to all of the panelists, and you can take your pick which you want to answer or both. So big question, how do you think the changes in the culture wars during the new era of President Trump, how do they inflect some of the things that you spoke about in the book? Or in what ways do you see the book as relevant to helping to resolve some of those culture wars? So that's one question. And a second is, what role do minority religions play? So we talked a little bit about the fact that there is a dominant Christian narrative, but so what role do minority religions play, or what role should they play in helping to shape the development and discussion of law and religion when they intersect or conflict?
So we're starting with easy questions then, are we? So let me take a shot at the second one. So one thing I often say, like, thank God for the Jehovah's Witnesses, otherwise the First Amendment course would be very boring, right? Like, so many of the cases are brought by this small minority in America. It's sort of interesting. One thing I think is very interesting about minority religions is there's a little bit of a what's good for the goose is good for the gander kind of approach that I think that typically many of the judges, if you look at the makeup of the federal bench, the numbers who are members of minority religions is quite small, right? Probably maybe scaled to, certainly not for Islam, not scaled to the population, but for some of them scaled. But typically, I think when a judge in the abstract is considering a particular piece of a religious challenge, and the challengers have, in many of these cases, especially as Liz was saying, these days with well-funded litigation tanks, have been Christians challenging something. I think one way in which it's helpful to consider the scope of a principle you want to announce in one of these cases is to consider what would that mean for a religion that's unfamiliar to you. And in some ways I feel a bit ambivalent about this possibility because it's essentially a way, it's slightly xenophobic, it's slightly alienating, it's about kind of imagining the other and feeling threatened by the other. But I do think that it's actually been somewhat of a bulwark in thinking about true expansions of religious liberty claims here, that arguments that say, well, if you believe this, what would it mean for X, Y, or Z religion or this kind of religious beliefs? I also think the role of, the question about the role of belief versus religious belief is very interesting and very complex. I mean, constitutionally, we do privilege religious belief, but when idiosyncratic religions, not just organized religions, but idiosyncratic religions, the rule is sincerely held religious belief, deism, that's enough. But when you think about reductios involving truly idiosyncratic beliefs, I think that also helps to be a limiting principle.
So I could pick up there on sort of the culture wars issues, though I think I'm going to give an idiosyncratic answer. So I think there's a couple of developments that are quite interesting over the past year or so. And the first has to do with the fact that it looks like healthcare reform is much more deeply rooted than part of our political spectrum thought. And that people are starting to think about it as a right of citizenship in certain ways, which leads me back to the book. I think that opens up a space for making changes around areas of the health law that seems to grate at religious employers in particular lately. So Holly Lynch and Greg Kerfman talk about the future of employer-sponsored insurance, and maybe the answer to mandates that infringe on employers' religious beliefs is simply to move away from our system of employer-sponsored insurance. And this responds to what Marianne Case calls the new feudalism in health insurance, where your fate is sort of tied to your employer's fate. And I think we're also seeing an interesting increased prominence of the religious left. And we see this in the context of undocumented immigrants, Catholic bishops declaring that Catholic churches are sanctuaries for undocumented immigrants. We have churches who are now bringing a separate statute called the Religious Land Use and Institutionalized Person Act. We have Unitarian Universalist churches that are bringing our LUPA claims against imposition of zoning requirements that would prevent them, for instance, from installing solar panels or adopting environmentally friendly building practices. And I also think that we're seeing some tensions around religion and workers' rights, not only in the area, well, what I talked about, contracting religion. No healthcare discussion would be complete without the Employee Retirement Income Security Act, or ERISA, everyone's favorite topic. But the Supreme Court just had a case last term, a sort of sleeper case on church plan exemption. ERISA protects employees' pensions. And the court said that church plan exemptions apply pretty widely, meaning that Catholic affiliated, religious affiliated, or even formerly affiliated Catholic hospitals, big healthcare systems, might be able to get away with defunding or underfunding pension plans for not paying out promises of pensions to workers. So we're seeing lots of tensions there that I think are part of our culture wars.
Great, thank you. And I want to add an addendum to the question as I join them for you.
Great.
Because I think some of the minority religions that you deal with often are at the heart of the culture wars. And I'm thinking Islam in particular, but there are others that you deal with as well. So can you say something about where you see the place of these minority religions with respect to these culture wars, whether positive or negative?
Another easy question. So, yes, yes. So, I'm gonna do a quick historical example to bring us to the fore, to recognize again not only how Christianity ends up defining so many of these questions, but also the fact that religion is absolutely always embedded in political and economic and social thought to give credibility to some representations and marginalize others. So if we were to be consistent with our concerns around religious freedom, of course, we would really be then consistently challenging for the Muslim ban, for example. We would be challenging the nature of how our immigration policy is being played out in the recent with the recent administration, and actually even from the Obama administration. So we would be, if we had consistency about the privileging of an understanding, a capacious understanding of religion, that would understand the intersections of the First Amendment and RFRA, then we would be having very different conversations, I think. The problem is that we tend to, again, do two things. We tend to idealize religion so that it's religious if it's what we like, and it's political if it's what we don't. So we'll talk about political Islam is not really Islam. Right? It's not the true Islam, or political Christianity is a Christianity we don't like, positive, real Christianity, or Buddhism in Myanmar, for example. So that's not really Buddhism, that's political Buddhism, or political. And that's a real problematic, fundamentally problematic distinction about religion itself. Religion is all those things. Religion is powerful. It's not a positive or negative force. It's a force. And the ability to distinguish that, I think, is really key. So, but we don't distinguish it. So therefore, we can have these, I think, crazy kind of schizophrenic conversations about religious freedom in one arena that's very much in the news, and about whether an owner of a bakery needs to make a cake for a gay couple, and feel like people can be on board with understanding what that is, and we'll take sides on that. And yet we don't extend that set of conversations to our incredibly divisive, incredibly destructive, in my opinion, debates now about immigration and issues related to immigration and refugees. So the role that religion's playing in this, I think, is not only the roles that religions are actually playing on the ground. I love that, Liz, you commented on the presence, always the presence of what we would now call more progressive or progressive end of the spectrum has always been present, but it's been really muted over the last, through the rise of the more conservative, primarily Christian, evangelical, and Catholic alliance that you mentioned. So again, it's a complicating of the religious spectrum, and I'm not going to go into what else I was going to talk about because I want to open up for the floor. But let me just say one other thing that all of us, no one's mentioned it, but all of us thought of it. The other nature of this question of minority religion is we have now a majority Protestant Christian group claiming minority status or claiming persecution status in relationship to the larger secular sphere. That's a really also needs to be unpacked, because that whole language of minority or marginalized, let's use the language marginalized, that now you will be shamed if you have religious representation, if you claim a religious belief, that there's a kind of secular culture that will shame you, and that this movement then becomes a movement to say, we will not be shamed, we will stand up for what we believe in, and we will forcefully assert that right. It's a dynamic that then again lends legitimacy to a host of problematic associations of religion that I think is really important for us to try to unpack.
Great, thank you. Questions?
In the back.
Yes, here in the back.
This question is for Professor Moore, but I think others might comment on it as well. I'm just curious about if you could expand on how the change happened with RIFRA from 93 onward. Was it because of health? Was it the HIV crisis and moving towards antiretrovirals? I know we're supposed to be talking about the United States, but Professor Cohen did bring in West Africa, so there's something specific, I think, about the United States in that regard, looking at some other countries where health was not a battleground for religion, right? It was actually, it's not seen, HIV/AIDS was not seen as kind of a religious issue in South Africa because of the difference of the epidemiology of the disease. And I was just in Singapore, and there it's kind of, you can have an HIV/AIDS organization even if you can't have same-sex sex decriminalized, because it's not seen necessarily as a battle like the conservative Catholics and Christians are taking on. So what was it about health becoming the battleground compared to, which I've kind of for a little while been thinking recently about health kind of being the way forward of the battle between law and religion?
Thank you for the question. It's a really important question. Now it's gonna bring me back to what I was gonna say earlier, which is so let me give the case study first. So the Southern Baptists, and this is in the book in our chapter, but the Southern Baptist Convention, which is known now to be one of the primary opponents of abortion, and very much at the forefront of public policy debates and efforts to roll back the legalization of abortion. In the 1970s, actually passed 3 resolutions that supported the moral legitimacy of abortion. The Southern Baptist Convention said that in cases of rape, incest, socioeconomic health of a family, and the woman's health, that in fact abortion is a morally sanctioned choice and we support it. And then there were a couple other resolutions that were similar along those lines. In 2003, the Southern Baptist Convention said all the previous resolutions about abortion are now null and void, and we're now making this resolution that abortion is murder. Earlier resolutions even said we want to find a middle ground between abortion on demand and abortion as murder. So they're now taking this language. So part of your question is that this intersection of religion and health happened very much around those 1970, not just Roe v. Wade, but also civil rights movement, women's rights movements, where reproduction and sexuality became the fulcrum for an organized backlash against those progressive movements. And that's where all the evangelical Christians came much more prominently focused in alignment with some factions of the Roman Catholic Church, although there were always other factions of the Roman Catholic Church that also challenged that. So for me, the intersection is I don't want to challenge the sincerity of belief by definition of people who are following this. I think people can hold deeply sincere beliefs about these questions. But the politicization of this is a perfect storm, if you will, and the organization of the religious right in the 1970s was absolutely the issues of reproductive choice was the full foundation for that organization. So and REFRA then became a piece of that. So it started out again in response to the Smith decision, where the unified response was to worry about the challenge to the First Amendment that many in Congress and the United States felt like the Smith decision represented, and then coming back, and the morphing of it is this notion of reproductive rights, the individual choice around, again, what are the issues on the table? Contraceptive, reproductive health, and sexuality. So this is I think, in relationship to your question, a really critical kind of intersection of how we moved from one understanding of REFRA to the current one that we're facing.
I'll maybe just add something about kind of the unpredictability. And again, I think this goes to Professor Moore's central point about the idea of politics and religion not being actually separable, and the attempt to, render unto Caesar that which is Caesar's. That's kind of wrong all the way down. But if you take reproduction, right, 3 strands of it, abortion, contraception, and reproductive technologies, you see the dog barked in 2, but not really the 3rd in America. That although Catholic teaching is against kind of all 3, Strongly, abortion has become a politicized battlefield. Contraception, kind of a quiet one. I mean, Hobby Lobby is sort of very interesting. The question of when contraception becomes abortifacient is kind of an interesting line. But reproductive technologies, many of the attempts to get personhood amendments passed in a number of states, which are aimed at kind of accelerating conversations and challenges to abortion regulation, founder on the fact that they sweep in reproductive technologies. And in America, the Catholic Church and other institutions that have kind of restrictive views on these things have never tried to make an enemy of the reproductive technology industry, because every person, even every religious person, tends to have someone in their family or someone in their friendship circle who has needed reproductive technology and struggled with infertility. Now, the truth of the matter is many people in their family probably have somebody who's had an abortion as well, but for some reason, coming out as somebody who's had an abortion is a heavily stigmatized and problematized thing. And so I think there's some interesting questions about contingency and why this happens. And then you could imagine a science fiction universe where religion is harnessed towards extremely progressive causes, even in this space. So I think about the way in which Native Americans recognize two-spirits individuals as kind of a religious identification within the trans community. And to imagine if the debate on trans service in the military became a debate about the religious liberty of Native American First Nations individual. Like, this is my alternative universe that some days I'd like to live in.
Actually, can I just ask you one more question about that? So you're talking about the future of religion, maybe, as it affects law, but what about the future of reproductive or just technologies in the health space generally as it affects law and religion?
Yeah, so there's always new things coming down the pipeline. I think the most interesting question I've been thinking about in my own thinking is, so in vitro gametogenesis, this is a technology where you can take an adult skin cell or another cell of the body and basically derive sperm or egg or an embryo from it. So imagine producing babies not from the old-fashioned way, not from the new-fashioned way of reproductive technology, but the new-fashioned way where no sperm and egg is required. So something I've been pondering is, for people who believe in potentiality views for criminalizing abortion, that the problem with abortion is it destroys a potential individual and potentiality is enough for personhood, how to think about skin cells in that respect, whether all of our skin cells are now have the potential to be children and whether they ought to have a different moral status. So I don't think I have an answer to this, but I'm kind of interested in this question, how you even wrap your head around it.
Great, let's go here.
Hi.
And then we'll go to
I hate to keep the focus on Professor Cohen as much as I love, respect, and admire him, but I just want to ask. It's really interesting that you brought up the Catholic Church in this country making a distinction between reproductive technologies that assist reproduction and obviously reproductive technologies that can limit reproduction. There are cases, and you brought up earlier, Italy is an interesting one. Law 40 made it such that any embryo that was produced for IVF had to be implanted. And Costa Rica is another weird one because they managed to actually outlaw IVF altogether. How did those conversations differ from the conversations that happen here? Is there sort of a logical reason why we went the path we did, but those two countries went a different way? Is it because of pluralism? Is it because of how religion and politics intersect here? Or is it just America's quirky?
So it's a great question, and I'm not enough of a comparativist to feel that I can give a truly definitive answer. Even if I was enough of a comparativist, I don't think I could give a truly definitive answer. But let me throw out one thing that's interestingly different, which is IVF and reproductive technologies are highly self-pay in the United States. Very few people, no public insurance, very little public insurance covers the more expensive formats of it. Much private insurance does not as well. As a result, much of it happens outside of kind of where governance technologies control. In more socialized medical systems, it's developed the case that I think it's much more on the attention and in the crosshairs of the regulators. So that's one difference. The other is to say that the Catholic Church, again, Catholic doctrine says the unitive and the procreative ought to be conjoined, right? That you can't have reproducing outside of sex is kind of problematic, right? But it's never been kind of a high point in the late 20th century of the things they emphasize. And whether that is also strategic on the part of the archbishops in terms of knowing who they will alienate or not. It's one thing to say that John Kerry can't take a sacrament because, he's not against abortion. Something quite different to say to your parishioners, all of you who want to have children or who have children, right, here's a problem. So I think it's a strategic speech to some extent too, but I've never been a bishop, so I couldn't say.
Great. Question in the back?
Yeah, I'm sorry to ask this question out of ignorance, and it's probably not a legal question, but you said that reproduction can occur from skin cells. Is that like cloning?
So it's slightly different from cloning, right, in that you might actually...
I mean, it's one individual?
So you could do it from one individual. You could also have, and again, this is something we've done in animals. We haven't done it in human beings yet. If an individual were to reproduce their own cell from a skin cell, it would be very much like cloning. But you could also derive an egg from one person's skin and a sperm from another person's skin and put that together to produce a new child. And this is something that we've done in mice with some success, believe it or not perfect success. And now there's pushes to do it in more mammalian species.
And
And you can capture those cells on a date in a self-driving car.
And I'll say, if you find this interesting, we'll be talking about this technology as well as gene editing at the Health Law Year in Review, Year in Preview in what month? And on December?
December 12th.
December 12th. So come back for more. We'll have George Church and we'll have George Daly from the Harvard Medical School and Eli Adashi all here talking about those technologies.
This book sounds fascinating. I look forward to reading it. I have a question actually for Professor Sepper. I'm curious to hear you say a little bit more about this intersection of religious issues and contract law. And I'm curious to hear a little bit more about what these contracts for people working in, for instance, a Catholic hospital look like. Are they contracting specifically, agreeing to work according to Catholic principles? Is it more specific? You're going to work in OBGYN and you agree not to perform abortions. And also related to that transfer of a hospital from a Catholic system to a non-Catholic, and that maintenance of Catholic procedures, is that at all contracted for in the sale, or is it more that there's a culture of Catholicism within the hospital system that just sort of persists after the sale of the hospital?
So the contracts look like other contracts. The provisions usually commit, with regard to individual physicians, say they could be in employment contracts, they could be in staff privileges requirements, and they essentially bind people to comply with the ethical and religious directives of the Catholic Church without saying anything else more specifically. As you said, OBGYNs are, of course, much more aware that this might affect their practice. So in lots of cases and in reality, there is slippage in certain institutions. So an OB may sign such a contract, but be told that, as long as you put that a woman needs contraception for a medical reason as opposed to a contraceptive reason, you're going to be fine. I hear this anecdotally all the time. St. Louis is chock full of Catholic healthcare, and that's what you hear from physicians. Certain procedures are harder to get around, as you could imagine. It's very hard to get around restrictions on abortion in a hospital, for instance. In terms of sales of Catholic facilities to non-Catholic facilities, the provisions are included in the asset purchase agreements, just like any other contract provision. Sometimes they are very strange. I've seen a very strange one that says, this provision is not enforceable at all, raising lots of questions about what it's doing in the contract at all, other than expressing, I suppose, to the Vatican that the Catholic health system is going along with what the Vatican might have wanted. There are others, though, in Boston when the Caritas Christi chain was sold to a for-profit investment group. That for-profit investment group operates all of those hospitals under Catholic restrictions. If a single abortion is performed against Catholic doctrine or tubal ligation or whatever in a Catholic facility, the bishop can intervene. The bishop also has people within the hospital system who are supposed to be watching over this. And if they think that the Caritas Christi hospital chain is out of compliance, such extent that they want to end what they've called a stewardship agreement on top of the sale, then there's a liquidated damages provision of $25 million. So that's sort of at the other end of unenforceability. Now, whether that could be enforced if push came to shove, that's a slightly different question. Maybe not.
Great. We just have a few minutes left, so I'll ask a final question to all the panelists. And here I'll ask you to imagine that you're a Supreme Court justice, or less imaginatively, imagine that you are an expert on law, religion, and health in the United States, and you may have something to say to a Supreme Court justice. And I want to return back to where we started with Martha Minow and some of the questions that Martha Minow raised. And there's one chapter in the book that talks specifically about religious reasons as opposed to constitutional and statutory reasons. And I think the discussion in general has been about where do we draw this line between religious freedom and other rights. So if there are favorite line drawing mechanisms that you have, like sincerity of belief or salience of religion, or if there are strategies that you might suggest employing, such as case-by-case balancing, what would you say to a Supreme Court justice if you're advising them on how to weigh the next case that comes before them on issues of law, religion, and health? I just asked the small questions.
Exactly, the easy ones.
Do ask small questions.
I would think so. This may be more predictive than it is advisory, but the third-party harm doctrine and this idea about third-party harm by religious decision-making, I think is where a lot of the action will be, and I think that there hasn't been enough attention to that. So the idea that to live in a pluralist world where there are religious and non-religious people, it's one thing to recognize the rights of religious people, but when it strongly implicates and creates significant harms to third parties who are not religious, that is something that ought to be thought about carefully.
I'll pick up on that point that I think is related. So Masterpiece, of course, is about anti-discrimination law, lots of current litigation against healthcare non-discrimination regulations, anti-discrimination law, and there is a rising chorus of voices that pick up basically on libertarian arguments from the 1960s that suggests that anti-discrimination law, that the governmental interest in law is satisfied where there are market alternatives. You don't need anti-discrimination law where there are multiple florists. You don't need anti-discrimination law where there are multiple employers. No harm, no foul. This is a deeply damaging notion for anti-discrimination law, I think, across different areas. And I think the Supreme Court would be well informed about thinking about really the equities, right? All of us are consumers. Only some of us are business owners. All of us are workers. Only some of us will be bosses. And these sorts of things matter for thinking about harm to third parties, but also thinking about whether and when exemptions from laws should or can be granted under the Constitution.
Last word.
First of all, I'd be just so happy that a Supreme Court justice was listening to a religious studies scholar. And my colleagues are much more obviously rooted in the legal issues involved here. But I think I think all our tests are inadequate, I'll say. So the Lemon test, Kurzman, they're inadequate. And how do we create, and what would it take to create a nuanced test? Because as soon as we start asking questions like sincerity, we're in a very, very murky water. And then if we're looking at only issues of institutionalized affiliation, we're also in really troubled waters. So I would urge the court to convene some significant opportunity for diverse communities of scholars and practitioners and legal scholars to come together to say we need a better test, at least and one that is somewhat malleable, but also can give some guidance going forward. Because right now we need something better.
So perhaps that's the next conference. Please join me in thanking all of the panelists.